This case starts like many sentencing hearings do. Routine, procedural, almost predictable. But what unfolds inside this Texas courtroom is a masterclass in second chances and what happens when you gamble with them. We're looking at State of Texas versus Satara Portillo, a deferred adjudication deal, 8 years, a $2,000 fine, community service, parenting classes, drug evaluation, a structured path designed to keep someone out of prison. Sounds manageable, right? Especially for a mother of two, ages 6 and 14, employed, managing properties, seemingly holding her life together. But here's the twist. This isn't just a simple probation check-in. Beneath the calm tone of this courtroom is a ticking clock, a required TAP evaluation, a recommendation for inpatient treatment, and one decision, one refusal, that will transform deferred freedom into a prison sentence. Deferred adjudication is essentially a legal lifeline. It means we're not convicting you yet. But if you violate conditions, the judge can sentence you anywhere within the full punishment range, in this case up to life in prison. So here's the question for you. When the court orders treatment and you refuse, is that defiance, fear, bad advice, or a fatal miscalculation? Because by the end of this hearing, we're going from probation terms to prison time. 5 years, just like that. Stay with me, because what happens next is a powerful lesson in courtroom consequences, probation pitfalls, and why I change my mind sometimes comes too late.
Court is calling 2023 CR 2172 State of Texas versus Satara Portillo. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Robert Porter.
All right, so we're here for sentencing. We've been waiting for the results of a UA and that result hasn't come in yet. Probation, do you have any idea when that will be ready?
That was done in off-site, so if I would have thought that we would have received it by now, the results didn't go on the day. It wasn't submitted on the day that the court required, so it took a little while to get her in. So right now we're just waiting. It was submitted on the 21st, so I thought it would be in by yesterday, today, but it still says today.
Okay. All right, Ms. Portillo, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand. How many children do you have?
2,
What are their ages?
6, and 14.
Are you employed?
And
What do you do?
managed properties, apartments,
Okay. How long have you been doing that?
8 years.
And does anyone live with you other than your children, or do your children live with you?
Yes, they do.
All right, anyone else stay with you?
My aunt as well.
When is the last time you've used any type of substance
I haven't used any type of substance.
in your lifetime?
Well, no, it's been quite a while.
So my question is, when is the last time?
Probably about a year and a half ago.
And what drugs were you using a year and a half ago?
Marijuana.
That's all.
Pause right here. What the judge just handed down is 8 years of deferred adjudication. That's huge. Let's unpack it. Deferred adjudication means there's no formal conviction on her record as long as she successfully completes probation. But if she violates, the court can enter a conviction and sentence her within the entire statutory range for the original charge. And remember what that charge is later confirmed to be. Possession with intent to deliver a controlled substance. Penalty group 1, 4 to 200 grams. That's not simple possession. That's distribution level weight. We're talking serious felony territory. The conditions are layered: a $2,000 fine, community service, parenting classes, a substance abuse evaluation, potential inpatient treatment if recommended, regular reporting, field visits, no contact with specific individuals, and even restrictions on working with minors. This is structured supervision with accountability at every level. Here's the key moment. The judge specifically orders her to follow all TAP recommendations. That clause will become everything. And I want to ask you, when a judge clearly outlines expectations like this, do you see this as strict accountability or as a genuine opportunity? Because what happens next hinges entirely on that one condition.
Oh,
Yes.
okay. This is what I'm going to want, probation. You need a pen? All right. It's going to be 8 years deferred adjudication, $2,000 fine probated. I'm going to want her on the patch until further notice. All right. So 8 years, sorry about that. 8 years deferred adjudication, $2,000 fine probated, a patch until further notice. I'm going to want a TAP evaluation done and follow all TAP recommendations. And counsel, if TAP recommends inpatient treatment, you'll need to come back to court.
Yes, sir.
There's to be 200 hours community service restitution. She's to complete parenting classes, and those hours will be waived once parenting classes are completed. And probation, you can decide which parenting classes you all think would be appropriate for her. Proof of employment. Y'all need to whisper proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Regular reporting by Zoom or in person. I'm going to want field visits one time every 3 months, random. And that's until further notice. Who is Michael Portillo? That's your
son.
juvenile child, right?
Yes, ma'am.
Who is Maria Avalos?
My ex-mother-in-law.
There's to be no contact with Maria Guadalupe Aveles. I guess that's how you pronounce it. Aviles. Avalos.
Could I say something though?
Sure.
Oh. Well, because my mother-in-law, we do have a lot of contact with my daughter, so. We have to contact each other. Because I'm not supposed to have contact with her, my ex-husband.
Oh, for kid exchange.
Yeah.
I'm gonna have to find somebody else.
I'll talk to him about that.
All right, thank you. Probation, is there anything else she needs? Is there anything else you need from the court to be successful?
No.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. And counsel, I believe I gave you a copy last time. Did you review that with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes. Sir.
All right, from here.
Listen carefully to what the judge says here. Everything that you do in your life, ask yourself if this could result in you going to prison for life. That's not courtroom drama. That's a direct warning. Judges don't usually repeat themselves like that unless they're signaling something important. And in deferred adjudication cases involving distribution-level narcotics, the range of punishment can indeed go up to life depending on the statute and prior history. This wasn't vague. This wasn't unclear. The expectations were crystal. And I find it fascinating because when someone is standing in front of a judge facing freedom versus incarceration, the gravity feels immediate. But probation violations often happen months later when the pressure fades and reality sets back in. So let me ask you, do people truly understand how fragile deferred adjudication is? Or does it feel like I beat the case when in reality, the case is still very much alive? Because now we're about to see what happens when condition number 35 comes back to haunt her.
Here on out, everything that you do in your life, there are two questions you should ask yourself before doing them. Is this something that could result in me going to prison for life? If the answer is yes, don't do it. The other question you should ask yourself, is this something that may result in me going to prison for the rest of my life? If the answer is yes, don't do it. Do you understand?
I do understand.
I take no joy or pleasure in sending the people to prison. But if it's warranted, I will. And your attorney will tell you I've sent people to prison before. So you have children,
Yes.
you need to look out for them. All right, good luck.
Thank you.
You're welcome. All right, court is calling 2023 CR 2172, State of Texas versus Satara Portillo. Could I have the parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
The attorney of record is Joanne De Hoyos. Joseph Statesman standing in. Ms. Portillo, will you give this court permission for me to do this in place of Ms. De Hoyos?
Yes.
All right. Ms. Portillo, did you review the document entitled Motion to Enter Adjudication of Guilt with your attorney? Did you understand it?
Yes.
Are you the same Satari B. Portillo who was placed on deferred adjudication in 2023 CR 2172 for the offense of possession with intent to deliver a controlled substance penalty group 1, 4 grams to 200 grams on July 27, 2023 for a period of 8 years? Is that you?
Yes, ma'am.
All right, state.
Violating condition number 35, on or about the 25th day of March 2024 in Bexar County, Texas, the defendant, Satara P. who then and there failed to follow the TAP recommendations to include inpatient as directed by the court in violation of condition number 35.
How do you plead to that?
This is the turning point. She pleads true to violating condition number 35, failing to follow TAP recommendations, specifically inpatient treatment. In probation hearings, true is essentially an admission. There's no trial on the violation. Once she says true, the judge can revoke deferred adjudication, enter a conviction, and sentence her anywhere within the statutory range. And notice something critical. The judge confirms she understands that she could receive up to life in prison and a $10,000 fine. She says yes. This isn't procedural fluff. This is constitutional protection, making sure the defendant knows the stakes. But here's where it gets dramatic. The state proposes a structured sanction: ISF, substance abuse programming, aftercare, weekly UAs, zero tolerance. And the judge says, essentially, I'm not following that agreement. That's power. In Texas, when it's an open plea on a motion to adjudicate, the judge isn't bound by recommendations. So now the safety net is gone. Would you have rolled the dice here, or would you have taken whatever deal was on the table? Because once a judge signals hesitation, the room changes.
True or not true?
True.
Your Honor, state waives all the violations.
Any objections to the state's waivers?
None.
Did you understand by pleading true to violation of condition 35, the court could find it true, grant the motion, find you guilty, sentence you up to life in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 35?
Yes.
Court will find violation of condition number 35 true. Is there a proposed agreement?
Yes, Your Honor, to alter demand for state ISF, the substance abuse program, followed by aftercare with ISP, weekly UAs with zero tolerance.
All right, so what I can tell you all, if you want to reconsider things, you can, but I'm not following that agreement.
We could step away for a moment.
We're gonna go back on the record in 2023 CR 2172, State of Texas versus Satara Portillo. Could I have parties announced for the record?
Daniel Escobar for the state.
Joseph Statesman, continuing to fill in for Ms. De Hoyos.
All right. The defendant had entered a plea of true to violation of condition number 35. Do you wish to continue with your plea of true in violation of condition number 35?
Yes.
All right, the court will find violation of condition number 35 true. Is there a proposed agreement?
Your Honor, if I may,
Yes.
I discussed this with the COO, Ms. Abrams, and ADA Daniel. My client is asking to be continued. We had a recommendation that was a three-way agreement. I understand the court didn't want to follow that. I had proposed something to Daniel. I'm hoping that you would consider this. But just some background a little bit first. Her prior MTR was disposed of February 27th, 2024. But she was booked February 3rd, 2024. So from February 3rd till today, according to the clerk, it's 137 days. So she's had the equivalent of a, not court ordered, but equivalent of a 4-month jail sanction. She will admit, well, she did admit that she refused to sign conditions for inpatient. She's willing to do not just ISF, she's willing to do SAT-F. She's willing to redo all her classes. She's been in jail for quite a long time. That's her own mistake. She admits that she didn't want to sign it. Maybe she was reluctant to, but she thought that she was supposed to get out, have court, and come back and do things, and she never left the jail. And out of frustration, she didn't sign the conditions.
No, I don't think she's a good candidate for probation. She was supposed to sign the conditions, the TAP recommended inpatient treatment, and she didn't do it. So I don't think she should be continuing on probation. She was given opportunity, and counsel, as you just stated, this is not her first motion to revoke. Her previous motion to revoke was on February 27th, as you stated, and there was a violation of condition number 1. And I ordered that there be a TAP evaluation.
This moment right here is raw judicial frustration. The judge explains exactly why this matters. She ordered a TAP evaluation. TAP recommended inpatient treatment. The defendant refused to sign. And now, after sitting in jail for months and facing a motion to revoke, she's willing to comply. The judge calls it out directly. You can't ignore court orders, wait until reality hits, and then decide to cooperate once prison becomes likely. This is about credibility. Probation is built on trust. The court extends supervision instead of incarceration on the assumption that the defendant will comply. When someone refuses a treatment order, especially after a prior motion to revoke, it signals noncompliance, not rehabilitation. And here's a hard truth. Judges see this pattern often. I didn't think it would go this far. But consequences in felony court escalate quickly. Let me ask you, should the system prioritize second chances repeatedly? Or is there a point where accountability outweighs opportunity? Because the judge is clearly leaning toward accountability.
Custody to follow those recommendations. And she decided that she didn't want to follow those recommendations. I don't see how there's anything that I can do anything for her. People don't get it. You're not supposed to, when the court orders you to do something, for example, to help you by following the recommendations of TAP. TAP recommended inpatient treatment. And I know sometimes people get to talking to people at the Bexar County Jail. And when I say people at the Bexar County Jail, I mean other inmates. And they give people advice, and people want to follow the advice of an inmate, not realizing that, guess what? That person is in custody. But I made an order, and we can't do this thing where I order somebody to follow the TAP recommendations, and the TAP says inpatient, and then somebody says, I'm not signing to go to inpatient. And then what ends up happening when reality hits that your range of punishment is 5 to 99 years or life, then people come before the court and they want to say, oh, you know what? I changed my mind. Now I will do inpatient treatment. So that's where we are.
And
I don't
Your
think
Honor,
she's a good candidate.
she's also willing to take a felony conviction, change it from deferred to straight probation. She's willing to do the harsher inpatient treatment program with 0 tolerance. It was a poor decision for her to not sign that. 4 months she's been in here. She's willing to sign this, willing to do this, and even add to these conditions.
I just don't think she's a good candidate. If somebody wants to argue to me why she would be a good candidate for probation, when this is her second motion to revoke, and I ordered her to follow the recommendations of the TAP evaluation, and she didn't want to follow them. But now she does because, I don't know, I guess she thought a motion to revoke would not be filed against her.
Yeah, I didn't know that that's what would result.
Oh,
I
so
thought
these are called consequences.
Well, Your Honor, also the charge itself, people who are affected with these substances may not make the best decisions in life. To prevent her from reoffending in the future, relapsing, and she's willing to do.
This detail is subtle but powerful. When the judge mentions the amount of methamphetamine involved, that's not accidental. In possession with intent cases, quantity speaks volumes. Larger quantities imply distribution networks, broader community harm, and heightened public safety concerns. The defense argues addiction impacts decision-making. That's a common and often valid mitigation argument. Substance dependency can impair judgment. But here's the tension. The original charge wasn't simple possession. It was intent to deliver 4 to 200 grams. That's a significant weight bracket. From the court's perspective, when you combine a serious drug offense, a prior motion to revoke, and refusal to follow inpatient recommendations, the patient's meter runs low. And notice how quickly the sentencing shifts after this exchange. Ira, we go from negotiation to finality. No dramatic speech, no extended deliberation, just 5 years in prison. Sometimes the quiet delivery is the loudest moment in the room.
Even more intensive inpatients.
But she's charged with possession with intent to deliver, and I understand that sometimes when people have possession with intent to deliver cases, sometimes they're selling because they're also using. But the amount of methamphetamine she had was 27.980 grams. I don't think probation is appropriate for her. I'm not going to continue on probation. I'm going to revoke her and find her guilty. Does anybody wish to speak to punish them?
Defense would ask for the minimum time, Your Honor, with credit for time served.
All right, I'll sentence her to 5 years in the prison. Give her credit for any time served. And I'll ask for the therapeutic community. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes.
But you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Do you understand?
Yes, please.
All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney.
And just like that, deferred adjudication becomes a conviction. 5 years in prison, credit for time served, therapeutic community programming inside the system. Let's recap what happened. She was given 8 years deferred adjudication for possession with intent to deliver a penalty group 1 substance, a serious felony. The court required compliance with TAP recommendations. Inpatient treatment was ordered. She refused to sign. That refusal triggered a motion to adjudicate guilt. She pled true. The judge was not bound by the state's proposed sanction. Given this was her second motion to revoke in a direct violation of a court order, the judge determined probation was no longer appropriate. Legally, the ruling falls squarely within judicial discretion. Strategically, it's a cautionary tale. Deferred adjudication is not immunity, it's conditional freedom. And once credibility is damaged in court, rebuilding it is incredibly difficult. So now I want to hear from you. Do you think 5 years was justified? Should the judge have given one more chance with inpatient treatment? Or was this the inevitable result of ignoring a direct court order? If you found this case as intense and eye-opening as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.